like to take a moment to answer the questions that we get asked the most from those wishing to contest a will. Those questions include, am I entitled to make a claim? And if so, how much will I receive? What are the fees involved? And also, what does the process involve? Hi, my name's Katie Zdadovic and I'm a litigation lawyer here at MKF Lawyers. Our lawyers have resolved various estate disputes, and so we understand the complexities of bringing a legal claim in relation to a will. We also understand that it can be a stressful time, and we're here to make this process as simple as possible and guide you through the legal process. So how do you know if you'll be entitled to bring a claim and how much will you receive? Generally, a spouse, child or grandchild is entitled to make a claim. There may be other circumstances where other people can bring a claim in relation to a will dispute. If you've been estranged from the deceased, you may still be entitled to make a claim. Some examples of when a claim can be made include the deceased made or changed their will when they didn't have capacity. There is concern about undue influence. The will doesn't reflect what you understand the deceased wishes were. You require greater financial support than other beneficiaries due to a medical condition, a disability, or your personal circumstances generally. Adequate provision hasn't been made for your education, welfare and advancement of life, or simply you've been left out of the will or have been left with less than the other beneficiaries. So what are your chances of winning your case? Your chances of winning your case will depend on several factors, including the legal arguments that can be put forward on your behalf, the evidence that can be obtained, and also the skill and expertise of your legal representation. How long does the process take and what's involved? The time frame is usually 6 to 12 months. It could be sooner than that period if it's a simple, straightforward dispute. Some factors that might create a delay in the claim being resolved is the complexity of the legal arguments and any evidence that might need to be obtained. The process is usually us having an initial discussion with you, and that can take place by telephone or in person. We'll then obtain details of the will and any other relevant documents. We'll also obtain details of the assets of the estate so that we can get an idea of the value. We'll provide notice of your claim to the executor of the estate and any other interested parties. We'll then put forward an offer to see if a resolution can be reached. After that, we'll participate in a settlement conference to ensure that you get the compensation that you deserve. It's necessary for you to provide notice of your claim to the executor and any other interested parties as soon as possible. It's also necessary for you to lodge documents in court to protect your claim within 6 months of a grant of probate or letters of administration. You should seek legal advice as soon as possible before this date. Click the Book Now button below to book a free consultation today.